Hello everyone, this is Thoughtful Thursdays by Tornado IP. We're here to teach you about reading patents, how experts read patents today. First impressions, what the cover page tells you in 60 seconds. And Mike Bow and I are continuing our discussion around the Ozempic patent. So most people often open a patent and they start reading it. And a lot of times they come to me and they're telling me, all I'm doing all day is reading patents and it's taking me so long. Well, the answer to that quandary is don't do that. The cover page gives you a critical context in 60 seconds, and we're going to demo for you how Mike and I read patents, which there's definitely some parts that are more important than other parts and can really save you a lot of time and eliminate superfluous reading. So some of the key answers you get from reading a cover page, it tells you if this patent is granted, tells you who owns it, where it's been granted, what countries, and tells you who invented it. So we're going to demo all of these from the cover page of the case study patent, Novo Nordisk patent, US patent 8129343. So a quick, cheap, free way to look at a patent is to go to your Google Patents browser, which is what I did here today, and put in the patent number. And when you do that, this page pops up, and right away you start seeing some of the things that the cover page will show you. But most importantly for our discussion today, it takes you to this download PDF, which I circled here. And if you click on that, it actually opens up the actual patent document that's been published from the patent office. And this is what it looks like. This is the Novo Nordisk core semaglutide patent. And we're gonna talk about some of the key dates that we're looking at here. So this patent was filed in 2006, granted March 2012, and it's about 70 pages long. The first priority publication data is publications here. Application data is here. Here we go. So there's three grant designation that you should look at on this cover page. These will tell you if your patent is granted, whether it's still pending or whether it's lapsed. In this case, if you look at the US number, it ends with a B2 designation, which means that it is granted. B implies granted, and that is the case in most other countries. Pending patents that are still undergoing examination by the patent office typically have an ending of an A. And pending patents do matter because most patents publish 18 months after the filing date. And this kind of publication starts the prior art clock. Now it's publicly known, publicly available. And so somebody else couldn't invent something that's publicly known. They couldn't file a patent on something like that. And similarly, old and withdrawn applications still would have published and they still count as prior art. Mike, do you have anything to add to that?
Yeah, so the publication date is interesting for several reasons. It's in your own work, for example, you have an invention, no one else knows about it. But if you're going to file a patent, the application gets to the patent office, but when it gets to the publication date, that means the whole world can find it. And if there's someone who's interested in your technology, they might well be tracking you. So you have to assume that everything that's written there, anyone can see. That's a benefit for you looking at others, but it's also something to be aware that others will know what you're at least considering patenting because you filed on it when that publishes. So it's no longer unknown to the world once that publication happens, and anyone can find it. Okay.
So these are some of the things that I was highlighting before. You see the application number here. You see the PCT, Patent Competition Treaty patent was filed on March 20th, 2006. The publication number for the PCT is shown here as well, which you could look up in their database. This is when it was published, which is 18 months after the priority application, the provisional application filing, and so on. And the US application number is also shown here, which is very different, but see, it ends with an A. And this whole patent, the PDF, if you do open it up, it's about 70 pages long. So you can imagine if you just started reading it without starting to look at some of this stuff, it'll take you some time. So the priority date starts the clock that really matters. The priority date is not the grant date, and it's also not the publication date. As I mentioned, the timeline is such that first you file, it gets published within 18 months. Then there's a back and forth with the patent examiner between the inventor, the patent agent, and patent attorney. That finally results in a patent grant, which might have claims that have different from what you intended in your application. And the expiration of your patent happens approximately 20 years from the original filing date. So after which your patent claims no longer protect your market in this way.
Hmm.
So this particular patent was filed in 2006. It expires March 2026 in most jurisdiction. And if you really are a company that cares about this market, you would check every single one of the patents you file in different countries might have slightly different expiration dates. And as Mike just mentioned, while the application is pending, competitors can already see your intent, what you're trying to cover. So assignee versus an inventor is another topic that you can uncover looking at the cover page, and it's a very important topic. The inventor of a patent is the person who conceived the idea that is in all the different patent claims. And it's a legal requirement to have accurate inventorship in a patent. Assignee is the person who owns it, or the company that owns it. And it's typically the employer of the inventor who owns and maintains and usually can enforce the patent. In this case, for the US 8129343, the inventors are Lau, Bloch, and Hansen. They're Danish inventors, and the assignee is Novo Nordisk. When you are looking at these things, it's important to watch for co-assignees, which often signal collaboration, joint ownership, or acquisition history. I think in our last episode, when we were talking about the Pentagon patents, we talked about how the Pentagon might collaborate with universities, national labs, and a lot of times that there'll be co-assignments. And the assignee does not have to be, there's no legal requirement for that to be accurate. So it is important to investigate a little bit further if you really care about a patent, who actually owns it. And there's various patent search tools that we demoed that can help you with that. Going to patent offices as well. Sometimes the assignee changes, the new owner may report it to patent offices, but it's something that to be watchful for, and don't just take for granted if you see an assignee listed on the first publication of a patent, that's still the current assignee. Any other comments on that,
if
Mike?
Yeah, sometimes when one wants to search work by a specific company, the assignee can have multiple names, or there could be, under a wholly owned subsidiary of, and so good patent search software sometimes will list that. I know DuPont, is the spelling of it different, or is there a different? Dow also had some multiple names sometimes, and so it's something to be aware of. And good software usually lets you select all the names that are relevant to the company, or that it appears under.
Yeah, and that's what allows you to set up alerts, for example, or like you really want
Yep.
to know what the patent portfolio of Novo Nordisk looks like. You would want to know if they acquired a couple of little companies and they have patents as
Yep.
well. And there's absolutely no requirement for them to change the assignee name with the patent office. It's still
Hmm.
enforceable if they acquired it. So the patent family really is a global footprint for a patent. When you have an invention, again, as I mentioned before, you're going to apply in a lot of different countries. The PCT is the type of application that this particular patent was applied under. It's called a Patent Cooperation Treaty. It allows one application protection in over 150 countries. And when the PCT application enters national phase, the assignee makes a decision with the patent attorney on what countries to roll it out further in. In this case, this U.S. patent that we're looking at is the national phase. Obviously Novo Nordisk wants to protect the U.S. market. They rolled it out in the U.S. in addition to many other countries. And typically, this is a really, really interesting thing to look at, the family size, how many countries you roll out in, because as I mentioned, the patent fees pile up. They can be very, very expensive if you have many countries. And a a company that files in many, 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 many different countries for a patent is indicating that this is commercially serious for them. They want to make that investment. Another thing that you can see on the cover page that is an indication of the value of the patent is the citations. And this is a topic we're going to cover in one of our next sessions in more detail. But this particular patent has 44 backward citations, which means they cited 44 patents that they built on. And citations typically are not just patents, but also journal articles. So any other related art that they built their invention on, they are required to cite, and the patent examiner also cites, and all of that is included in the citations of a patent. For this particular Novo Nordisk patent, some of the citations are as old as from the 1990s, and this particular patent is not surprisingly cited by 255 other patents, which is a very good indication that it's a really, really important patent. So if you were to look at all of Novo Nordisk's patents, and that's your homework, to look at all of their patent portfolio, one of the clever ways to look at the most important patents is to look at the ones that are most highly cited first. Similar to a journal article, if you come up with something really clever, a lot of people are going to be citing you, and it's the same is true for patents. Mike, do you have anything to add to that?
A highly cited patent that say it's 15 years old and it has several hundred citations in the future, you're also interested in which of those are future cited. If there's a later patent that cites something from 15 years ago, those later ones may be cited. It's like a second generation of citation that might not be noted in the older one. So again, if it's a very rich field, you might have to do a couple generations of forward citations, depending on what you're looking for. But who else is following this art? And maybe there's something newer than that that cites a first round of citation.
Yeah, and we're gonna delve into that in one of our next episodes. So basically, what we wanted to cover today is what to look at when you first look at one of these PDFs to really just give yourself a quick glance of some take-home messages. And one is the grant status. You're likely going to be able to uncover if this particular patent is granted. And if it's not granted, you might find another family member that is granted, and it might be more relevant to look at that for the claims. You will be able to see the priority date, which determines, that starts the 20-year clock for the enforcement of a patent. You will be able to see the assignee, with a little bit of caveat, might or might not be accurate. You will see the inventors. You see an indication about the family size. You're going to see some indications about other countries where it was filed in, as well as you're going to see forward and backward citations. So, take home message, don't start reading, start orienting first. And next up, we are going to move on to episode 3, where we'll talk about claims are everything. It's basically the deed to the property. And Tornado IP Consulting is here to help you in your specific area. We're happy to work with you and train you on how to read the patents in your space, how to make sure you have alerts set up, and give you a pulse check to have an understanding of the key most important patents and the top 10 moves in your competitive patent landscape, and support you in IP strategy execution. So thank you for listening, and stay tuned for our next episode of Thoughtful Thursdays, where we're going to talk about claims, and claims.